Good morning. I would like to welcome the early risers and hardworking people to the Finance, Ways and Means Committee, which is now being called to order for February 7th, 2024. Mr. Clerk, would you please call the roll?
Representatives Barrett, Boyd, Camper, Cochran, Crawford, Faison, Freeman, Gant, Garrett, Hawk, Hicks of Hawkins, Hicks of Washington, Kiesling, Lamberth, Love, Lynn, McKenzie, Miller, Moon, Parkinson, Shaw, Sparks, Whitson, Williams, Zachary, Vice Chairman Baum, Chair Lady Hazelwood. Madam Chair, you have a quorum.
Thank you. And I noticed many people were too tired to say here, but we do recognize that you were visually present. So thank you for being here. Are there any personal orders or announcements? Representative Miller.
Thank you, Madam Chair Lady. I wanted to announce my intern, Sarah DeKeffa. She's sitting over here from Trevecca Nazarene University.
Welcome.
Thank you, Madam Chair Lady.
And I think I did this earlier, but in case I did not, we too have an intern in finance, Baxter Yarborough. He is a grad student at Vanderbilt. So if we've welcomed him before, welcome him again. He is doing a lot of good work for us. Other personal orders. Well, I have one. I would like to ask everyone to join me in a moment of silence in recognition of Captain Larry Taylor. His interment is today in Chattanooga at the National Cemetery. Captain Taylor was just awarded the Medal of Honor just a few months ago. President Biden gave him that. It was a long-delayed honor, recognizing heroic actions that he took during the Vietnam War. He was a helicopter pilot. There were men who were they were surrounded, they were outnumbered. His role was not to get them out. His role was to fire upon the enemy, but he knew that those men were going to die if he didn't do something. So against orders and the way that Army helicopter pilots were taught at the time, he landed his helicopter. Those guys hung on to the skids, and he got 4 men out of there who would have otherwise been deceased. So heroic man who gave so much to this country and came back. He was my constituent, lived on Signal Mountain, and contributed to the community for all the years after that as well. So if you all would just join me in recognizing and celebrating the life of Captain Larry Taylor. Thank you. Representative Parkinson.
Thank you, Madam Chair Lady. Madam Chair Lady, today is a very special day, and I don't want to get whooped when I go back to 419. Today is my assistant, Vanessa Horner's birthday. So if y'all can just wish her a happy birthday, that would be awesome. Thank you. And it'll save me some pain, too. Thank you.
All right. Well, again, thank you all for being here early as we begin the process of our budget hearings. Well, we actually began those yesterday with an overview from our Commissioner of Finance. But today we will start digging into different departmental budgets, and we will begin with our Attorney General, and we will ask General Scometti if he would to come to the table with his staff members that are going to provide his moral and otherwise support.
Thank you, Madam Chair. I need all the moral and otherwise support I can get. I'm Jonathan Scometti. I'm the Tennessee Attorney General and reporter appointed in 2022. So this is my second time before the committee. Joining me here are my Chief Deputy Attorney General, Lacey Mace. She oversees the litigating divisions in the office, and Kelly Smith, my Chief Operating Officer, who oversees, among other things, the budget. And I'm very fortunate to have a great team. I do want to brag on them a little bit. Tennessee is so well represented in court. We're very, very busy. We have a lot of cases. We got about 16,500 open matters right now. We have about 200 attorneys, and they are working very hard on behalf of the people of Tennessee. Taxpayers are getting their money's worth out of us. This year, we're asking for about $69.6 million, but we've brought in about $224 million to the state through various settlements. So we aim to continue to be worth a lot more than we cost. And I want to highlight just a few things that we've been working on that I think deserve recognition and that I think you'll be interested to hear about. The first is opioids. And this is something that General Slatery, my predecessor, was very engaged in. He was a national leader in it. When I was working for him as his chief deputy, I worked a lot on these issues with him. He was the architect, along with some of the folks on our team, of a number of significant national settlements. And so we've started putting money into the opioid abatement fund, which is something that the General Assembly authorized. The governor's been working with the General Assembly on that. And it is dedicating our settlement money that goes into that trust fund exclusively to the purpose of issuing grants to fight opioids. And we've got settlement commitments totaling over $1 billion that are going to go into that fund over the next 20 or so years. And we continue to get more money. We just settled with this French marketing company recently, Publicis, which had done marketing for Purdue Pharmaceuticals. And that's going to be another $9 million into the opioid abatement fund. So we're continuing to plug money into that. It's obviously a significant crisis, and we're very proud of the work that we've done to help provide the state with ammunition to help Tennesseans. Tennessee is also one of the leading states, us and Colorado, in the litigation and investigation of social media companies for the mental health impact they're having on young people. I know this is something that the legislature is also interested in. This is something that's been getting national attention. Senator Blackburn's been very active in this space as well. We have a suit against Meta right here in Davidson County Chancery Court. We're fighting with TikTok right here in Davidson County Chancery Court over discovery issues. But this is an industry-wide campaign, and I'm really proud of the Tennessee attorneys that have been the point of the spear on this. I mean, they have been putting together the case. They've been coordinating. They've been doing a great job. And given the impact on kids, it is so important that we get this right. So we're going to keep fighting on that front. I think you're going to hear more about it soon. And then there's a lot to talk about. I'm not going to talk about too much more. But the one case I wanted to bring up on the constitutional side is the LW case. This is the case against HB1, SB1 from last session. It's the bipartisan bill prohibiting pediatric transgender irreversible interventions. And every federal court that had heard one of these cases prior to LW going up had ruled against the state. So there had been state after state after state that tried this and was unsuccessful. Tennessee was the first state to win one of these cases. And the principle there, our job is not to go in and tell the court what the law should be. Our job is to defend the democratic institutions of Tennessee. The General Assembly is elected by the people. This is America, and the people make decisions. And whatever decisions the people make, unless there's a clear constitutional obstacle, the court should step back and let democracy run its course. And so we were able to get a ruling, a very good ruling from the court that said just that this is an issue where there's a lot of disagreement. And in situations like that, the elected representatives of the people should decide. And I think that's going to be an opinion that helps us out a lot in a number of future cases. But I did want to highlight as well, that we got a big win in that constitutional case. We are not, the budget gives us the mandated salary increase, which is a statutory issue. It does not provide any additional positions or anything other than, I think, the cost of living increase. We're very grateful for the additional salary money we received last year for market adjustments. We've been trying to calibrate that. We're still a little bit behind the executive branch, but we've been able to significantly increase line lawyer salaries in a very competitive market here in Nashville. And so our turnover is down. We've been able to recruit effectively. We've got some great new lawyers. And as the senior attorneys retire and age out, it's really important that we restock and keep people long enough that the office can remain effective representing the state in the many, many thousands of cases that we have. So I'm grateful for what you've given us. We're going to continue working hard for you, and I'm happy to take questions. Thank you, Madam Chair.
Thank you, General. And I'm glad to know that our salary market rate adjustment has, positively impacted your ability to recruit and retain. I would remind you that we have a large attorney pool in Chattanooga, and we'd welcome a satellite office that, and we would certainly be willing to help you, recruit and retain in our part of the state as well. So
Yes, ma'am.
just for future reference. All right. Thank you. I have a number of questioners. Chairman Whitson.
Thank you, Chair Lady Hazelwood and General Scametti. Good seeing you this morning. I just want to tell the committee I am very proud to be your state representative, and I just appreciate so much that what you and your team do for the citizens of Tennessee. You make us all proud. And so my first question has to do with the Strategic Litigation Unit. Last year, 2.3 million in recurring funding was appropriated to create the Strategic Litigation Unit with 10 positions. Can you give us an update on those 10 positions? How many have been filled to date, and are they all attorney positions, sir?
So 8 of the positions are attorney positions, 2 are support staff. Hiring the right people for this is really important to me. These are very complicated cases we're looking at. It took a while to find the right director for it. Pardon me. So I want to talk a little bit about her. She's a Franklin native. She has been up in Washington, D.C. for a while, and she wanted to come home. When she was in Washington, D.C., she clerked for Brett Kavanaugh when he was a D.C. Circuit Judge. Then she went on to clerk for Justice Samuel Alito on the U.S. Supreme Court. Then she went to work at one of the most prestigious law firms in Washington. Then she went back to clerk for Justice Amy Coney Barrett on the Supreme Court. Then she worked a little more in very sophisticated appellate practice, and we were able to bring her down here to work for the state. We've hired 5 people so far out of the 8 attorney positions. We have a former assistant U.S. attorney. We have someone who came down from the Solicitor General's office in Kentucky and who clerked for a 6th Circuit judge, as well as Judge McFadden on the D.C. District Court. We have someone else who clerked for Justice Campbell on the Tennessee Supreme Court, and for Kyle Duncan on the 5th Circuit, and for Judge Varlin out in East Tennessee, and then another person who clerked for Justice Campbell. We have been interviewing aggressively to fill the additional 3 lawyer spots. Strategic litigation is very busy, pushing back against administrative overreach. In addition, we've got a suit against BlackRock, a consumer protection suit. So we need to hire up to keep up with the cases we have there. And I anticipate we'll have all those spots filled. Support staff spots have not been filled yet. The priority is getting the lawyers in.
Chairman Baum.
Thank you, Madam Chair. And I want to thank you, Attorney General Skrmetti, for the work you're doing. You're working on some important cases, and on behalf of us and Tennesseans, and we all recognize that. I've got a question about reserves. Over the last year, or between fiscal years, the amount you have in reserves has increased, almost doubled. And I think this is partly due to litigation settlements. The amount you have in your litigation settlement reserves has significantly gone up. You even received a payment recently for an e-cigarette case. And so my question is, how does your office utilize these reserves?
So we use reserves to fund a number of positions and pay for litigation expenses, usually in the consumer protection sphere. And some of the senior management is paid through reserves as well. And I may be missing a few other things. The reserves right now are fairly swollen, in part because of the Juul settlement on e-cigarettes. We've been working with the Department of Health to figure out how to set up a program to educate and deter kids from using e-cigarettes. And I believe we are about through with the plan, and we're going to send money their way. My understanding is best practice is to keep 3 years worth of reserve funding in the reserve. And we typically will send any overages back to the general fund. The reason we haven't yet is because we've been trying to figure out the Department of Health situation. We're excited. They've been working hard, putting together a plan to put that money to good use and protect the safety of kids in Tennessee.
And maybe as a follow-up on that, do you have a target amount you want in these reserve funds to indicate how much extra you can spend and draw down?
Yeah, 3 to 5 years is best practice. We aim for 3 years, and what's our? Yeah, we're at 5 years worth of reserve right now. Once the health money goes out, we'll take a look, calibrate, and whatever is over 3 years, we'll return to the general fund.
Okay, thank you for that information, and we're pulling for you in court.
Thank you.
And just to add my gratitude on the vaping issue, I have teenage grandchildren. They don't vape, but they tell me that it is so widespread on their campus and among their some of their friend groups. And it's, we've spent a couple of generations getting people to stop smoking and to understand the hazards of that. And now this is just, at least in my view, undermining a lot of that and putting chemicals that nobody really knows what the harm may be long term for a lot of those who are just not the studies. But you have to think it's probably God didn't intend it to be there; He would have put it there in the first place. So you can't have to think that it's not healthy. So I do personally appreciate your work in that arena and look forward to whatever you do with our Department of Health to try and engage young people and at least, of course, all young people think nothing bad's going to ever happen to them personally. So getting through that mindset, I know is very difficult, but we have to try. Chairman Moon.
Thank you, Madam Chair Lady, and good morning, General Skrmetti. I have a few questions about salary market adjustments, and you addressed some of this in your opening remarks. In the FY 23-24 budget, appropriated $5.1 million, including $922,000 in other funding for salary market rate adjustments for your agency. Can you tell us the source of this other funding?
May I phone a friend, sir?
Sure.
And just for the record, if you would identify yourself, please.
I'm Kelly Smith, and I'm over operations for the office. And I am going to talk to our budget director, and we can follow up with you on that number. I don't have that specific number in front of me, and I don't want to give you misinformation. So if that's okay with you, we'd love to follow up about the source of that. Okay, wonderful. Thank you.
If you would just get that to my office, then we'll share it with the committee as a whole. Chairman Moon.
Thank you, Madam Chair Lady. And you did address this in your opening remarks. Are the salaries for the attorneys in your agency now more aligned with attorney positions throughout state government? And then a follow-up to that, are they competitive with the private sector?
They are coming closer to alignment with the rest of state government. My understanding was we're still a little bit shy of where a lot of the executive branch positions are, especially in the 2 to 4 year attorney range. They are not remotely competitive with the private market, which is a serious concern. The Nashville legal market's very hot. I think starting salaries at the firms are in the $160,000 range now. We don't crack six figures yet for our starting salaries. And actually, one initiative that I am interested in pursuing and was hoping to start this year, but it's maybe not the budget year for it, is looking at satellite offices so that we can get broader recruiting pipelines because Nashville is so hot. But yeah, there's a huge disparity, and it is a constant struggle to keep people from leaving. We have tough cases. We need good lawyers. You have good lawyers, and the firms start looking at them and offering them very substantial salary increases. And so this is something we're constantly worried about.
Chairman Moon.
Thank you, Madam Chair Lady. Are the salaries of the non-attorney positions within your agency aligned with similar position salaries in state government, your support staff?
Those are pretty aligned with the other parts of state government. Yes, sir.
And we wish you well with the NCAA, sir.
Yes, sir.
Thank you, Madam Chair Lady.
Thank you. Chairman Boyd.
Thank you, Madam Chair Lady. And General, it's great to see you today and appreciate everything y'all doing for us and fighting the good fight. Have a kind of a follow-up question to what Chairman Moon said with regard to this salary market adjustment. I understand you had a little bit of latitude to make adjustments at each position or employee class. How did you do that within your agency?
So it's a combination of looking at experience, comparing that roughly with bands of relevant experience in other places in state government, comparing it with market value on the open market, looking at specializations and looking at productivity. There was no set formula.
Madam Chair, thank you. And so I know you mentioned a minute ago that you still have problems with people trying to recruit your attorneys into the private sector. Have you seen that reduce a little bit though with this market rate adjustment?
We have, and it's not just the salaries. In addition, we've made all sorts of employee-oriented changes. The dress code has been relaxed, and we try to have more scheduling flexibility, and there's accountability there. We make sure everybody's working hard, but because the private sector is so aggressively hungry for attorneys, we're taking a full spectrum approach to trying to keep people, but salary is easily the most important part of that.
Thank you, Madam Chair Lady. That's it.
Thank you, Madam Chair. In general, and Ms. Smith, Ms. Mace, I noticed you have some orange on today, and I say that's not by accident with UT Day on the Hill. So thank you for recognizing that. I have heard that the potential or probable federal case may be tried in the Greenville Federal Court. So if you need to know where the coffee shops are, the restaurants are, you're welcome to call me at any point in time if you're going to spend an abundance of time there.
Yes, sir.
Thank you. I do want to go down the road, and this is somewhat historical. 5-6 years ago, there was a certificate of public advantage in the healthcare arena that created the healthcare system in Northeast Tennessee. There is a COPA monitor. Is that individual employed by you? And you may have to get back to us on this. Is that COPA monitor employed by you, and what type of oversight is your office and the Attorney General's office providing currently? Thank you.
I can speak broadly to that, but I think for the details, we would need to get back. And we just, in conjunction with the Department of Health, hired a new monitor. He was the head of the UT Knoxville hospital system. We do contract that, right? Yes. We will get back to you with the details, Mr. Chairman.
Chairman Zachary.
Thank you, Madam Chair. Good morning, General. It's good to have you. Thankful for you. You are as assertive and engaged as any AG in the country. Your team has been fantastic and very accessible to us. So, man, we appreciate you and your team. Just quick question related to two questions related to your suit on behalf of student athletes. If you could give us an update, because there was some information. I thought Chairman Hawk was going there, but he stopped short. So if you could give us an update based on some of the information that came out yesterday and the judge's favorable comments toward that suit. And then also, if you could update us a little bit on the BlackRock suit and where we stand on that, please.
So with respect to the student athlete suit, we brought a Sherman Act antitrust suit. Oh, whoop. Can you hear me now?
Yes.
All right. With respect to the student athlete suit, we brought a Sherman Act federal antitrust suit on behalf of student athletes in Tennessee. So that's all the prospective students in high school here, all the students who may be coming to the universities here, any student who may be eligible to transfer. We had asked for a temporary restraining order. We moved very fast. A case like this should have taken about 6 to 9 months to put together. We did it in about 3 weeks. My team, I'm surprised we haven't lost anybody off that. They did a phenomenal job. So we asked for a temporary restraining order. Those are hard to get. We did not get one. But the judge, when he was going through the analysis, said we are likely to succeed on the merits. That's one of the factors you look at. So we in Virginia brought the suit. And he said we're likely to win and that there is an antitrust problem here, that the NCAA appears to be engaged in illegal anti-competitive behavior. We had said we needed a TRO because there was irreparable harm. And the judge's analysis, and we had made arguments to the contrary, but his analysis wasn't terrible. It said, oh no, they can pay for it. We can figure out how much this costs. And in an antitrust suit, it's treble damages. So we're potentially looking at a pretty significant verdict. But I think the more important thing is getting a declaration from a federal court, and I have no doubt it'll be appealed up, and it may well go to the U.S. Supreme Court, but a declaration that some of the limitations on student athlete outside NIL income violate federal law. And that's something that's been percolating up for a long time. given the way the NCAA has treated the University of Memphis and the University of Tennessee, I'd be lying if I didn't say I was looking for an opportunity to push back. Didn't expect it to be quite so dramatic or abrupt. And then with respect to BlackRock, we sued BlackRock on a consumer protection theory. So ESG is very hot. I know that the General Assembly's passed legislation on that and been concerned about this. This is not a suit that's saying anything that BlackRock is doing in terms of ESG is inherently illegal. We're not suing in this suit over fiduciary duty. What we're saying is they were sending mixed messages to consumers. Pardon me. So sometimes they would say they were going to do nothing but focus on return on investment, and that if you invested in a BlackRock product, they would maximize your return. Sometimes they were saying they would use everything they had to try to improve the environment, and that they were going to leverage their assets under management, which is almost $10 trillion in assets, to push for policy changes. And you can't do both. I mean, it's America. If they want to be straightforward with people and say, if you invest in this product, we're going to use it to invest in environmentally sustainable companies, that's fine. The problem is the consumer confusion with two different messages coming out. And so what we're looking for is clarity and transparency. We filed suit. We're waiting for a response. It may be something that we can negotiate a resolution that brings that clarity, or it may be something that drags out. I think it's fair to say there's a lot of action in this space legally. We were the first people to sue any of the big asset managers related to ESG, the first state in there. There may be additional suits down the road. Our suit is a relatively modest consumer suit. And as I said, if we can secure transparency with that suit, that'd be a great win, but we'll see where it goes.
Thank you. Thank you, General. Thank you, Madam Chair.
Representative McKenzie.
Thank you, Madam Chair. I'd like to pull that string a little bit as it relates to BlackRock. So in terms of investments and investment over the course of whatever 10 years, how's BlackRock done with our state's money?
I'm not sure offhand. I'd probably defer to the treasurer to talk about returns because that's his specialty.
Representative McKenzie.
Thank you. So, very good point. Did the Treasury ask you to start this lawsuit? Is that you said that's their specialty as it relates to funds and investments of those funds?
No, this was based on looking at the messaging to consumers and determining that there was a Consumer Protection Act violation in the contrary messaging coming out of the company.
So,
Representative McKenzie.
thank you. So, as it relates to that, what other when you looked at that, are there any other aspects that BlackRock is investing on that may send another message? Are they investing with companies or focused on companies or entities that have a different kind of that's assuming that they are actually looking at these environmental companies or whatever intentionally? Are they intentionally sending any other mixed message in your research? And what I'm saying is, have you investigated from A to Z what their messaging philosophy is? And can you tell me without a doubt that they're not using any other aspects to target their investments?
They market multiple products, so they have different products that they'll sell to investors. Some are explicitly ESG oriented, focused on environmental sustainability. They have others that are based on different investing philosophies that people may have. Our concern is not with the individualized products, because as long as they're clear about what's going on with those, it's not a problem. The issue was they were making blanket statements about their investing philosophy, sometimes saying that they were strictly focused on ROI, except of course when they're explicitly saying that there's a product that's not, but saying that their default position is only to focus on return on investment. but sometimes they were making statements about how they were going to leverage every asset under management, which means all of their different investment products for the purpose of promoting environmental sustainability. And again, the problem is not what they're doing. The problem is they're saying two different things, and a consumer investing in one of those products won't have clarity necessarily about what the investing philosophy being used to invest their money is.
Representative McKenzie.
Yeah, this a final question statement, I guess. You know, as I looked at it, I think they have multiple things that they're saying that they're focusing on, depending on the time and the temperature of the market. The market may be more environmentally sensitive, and those funds may be doing well during a particular time, whereas other times, other funds, and I think they have expressed that fluctuation on with their focuses on other things, but it's all market driven. So they've done well. As you say, trillions of dollars that they manage, and they have other philosophies. They do. I've seen other philosophies. So for this particular one to have a lawsuit, I think is a bit drastic. And I guess I'll ask, as you combined with other states, and I've seen headlines where 12 states have joined in this lawsuit, 12 other attorney generals are joining this lawsuit or that lawsuit. How many other states joined in this particular lawsuit? And explain, and because it's my last question, explain why not others haven't joined, please.
So no other states have joined this one because other state consumer protection laws don't reach securities marketing. But there's a Tennessee Court of Appeals decision from about 20 years ago, I believe, that says that marketing of securities products does fall within the scope of our Consumer Protection Act. And so, a number of states have been looking at ESG issues, which is why I said this may not be the last ESG-oriented state lawsuit. But we are, I believe, the only ones in a position to bring the consumer protection suit and bring that clarity. And I think if we can bring clarity to it, excuse me, and ensure that there's transparency about what's going on, that may resolve some of the other issues. If you look at, it seems like there's a shift going on in the financial sector where ESG is cooling off to some extent. And you're seeing some of the companies back away from some of their bolder commitments. I think there's still going to be sustainability products available to consumers who want them. But in this suit, because we're the only ones who could bring it, we're the only ones who brought it. I suspect there are a lot of other states that would love a chance to jump in on a suit against BlackRock, but their state law may not support such a move.
Thank you, General, and I will just stay tuned, and that's what the courts are for, to determine the validity of these sorts of claims. So we'll look forward to an update next time we're together. Leader Camper.
Thank you, Madam Chair. I'll make mine quick. I know we're out of time. Thank you for being here. I had a question around the governor's proposed budget, where he's looking at the getting rid of the franchise tax. And I can't remember, but I thought he said it had something to do with an opinion from the AG. So I was curious, was there some opinion that you did that drove this decision? I did ask the Department of Revenue, was there any pending litigation for the record? And he said no. So I'm just curious as to what the opinion was that you gave that drove this decision. Thank you, Madam Chair.
Thank you, Leader. There's no formal AG opinion involved in this. We provide legal analysis to our clients, and we don't make policy decisions, but we do identify legal risks and provide information to allow the policymakers to make informed decisions. If you would like to sit down with my financial team to talk about some of the legal issues surrounding this, we'd be very happy to do that. Because of reasons that I don't want to state publicly, we can't get into it very much publicly. But we are happy to provide a legal analysis and answer any questions. in an attorney-client privilege context with all members of the General Assembly.
Leader Camper.
Thank you, Madam Chair. Thank you for that. I'll reach out to your office.
Yes, ma'am.
All
Thank
right.
you.
We do have some other questioners, and I would ask you all to follow Leader Camper's lead and be brief as we are over time, and we have a pretty tight schedule today. Representative Shaw.
Thank you, Madam Chair. Thank you, gentlemen, for being here. And I'm going to be very quick. I'm surprised this has not came up. Are you getting any complaints about AI in any way right now?
We've had a few complaints, and I used to teach cyber law at the University of Memphis. My dad was actually an AI researcher, so I'm all about that stuff for fun. I mean, I read those articles for fun. We've done some letters to the federal government. I think you all know I'm not necessarily the biggest fan of federal regulation, but Jason Miyares in Virginia and I were the Republicans co-sponsoring a letter encouraging the federal government to regulate more. We're trying to support congressional efforts to regulate AI. I know the Elvis Act is out there. I think that's a great piece of proposed legislation from an AI perspective. We have not had a ton of consumer complaints yet, but I'm very worried. In New Hampshire recently, the New Hampshire AG went after a company that was doing some AI robocalls around the election, and it was faking President Biden's voice and telling people not to vote. And that, I think, is a precursor of what we're going to see a lot of, not just in the election context, but consumer context. So we haven't had a lot of complaints yet, but I think a lot of people are worried, and they should be. And we are happy to work with the General Assembly on these issues. I know the governor is very concerned about these issues, and we're going to keep an eye on it, especially from a consumer perspective. And we will not hesitate to file lawsuits as appropriate there.
Thank you, Madam Chair. Thank you, sir.
Miller.
Thank you, Madam Speaker, Chairman. Quickly, Attorney General, of the 80 companies that initially approached the state in reference to the franchise tax refund, were they organized, or did they come individually? And I know you're limited to what you can talk about, but I'm just curious about that.
So there are some really, really strict laws involving the disclosure of any communications related to anything touching on taxes. In addition to attorney-client privilege issues that arise relating to communications with any of our clients, including any of the cabinet agencies, about legal issues. So to the fullest extent possible, we would be glad to answer your questions in a private setting, but I can't talk about a lot of things dealing with confidential legal issues. Yeah, I hate the non-answers, but I apologize. I mean, we really can't get into it in a public setting.
Currently, are we under any lawsuits with any of the 80 companies?
No, sir.
Okay.
No, sir.
Okay. Last question. Your predecessor and former Attorney General, between 2014, 2022, you were just appointed, pretty much. Was he a part of advising the governor and Commissioner of Revenue that we need to look at this franchise tax refund issue? Was he a part of that discussion?
So I can't.
That's a yes or no.
I apologize for not being able to get into that because of privileges. I will say there's a Supreme Court case that's fairly recent dealing with franchise tax issues. And I apologize for not being able to give a more fulsome answer than that.
Well, as we deal with your budget, and for me to support your budget, I was looking at this $1.2 billion and then the $410 million recurring. And I was saying, wait, we could really help fund your budget if we didn't, Thank you, Madam Speaker.
General, thank you so much for being here today. And again, I think it's been mentioned a couple of times, but I appreciate your staff. They've been very, I'm working on an issue, as you well know, in the social media kind of realm. And your folks have been really helpful, and I appreciate all the work that has gone into that, and we'll continue to go into it as we go through the process. And I know that you work with not only the administration, but individual members with our caucuses and so forth. And we do appreciate what you and your attorneys and the rest of your support staff do to just make sure that Tennessee is on the right legal path, and to make sure that to the best of our ability, we make sure everybody that we interact with is as well. So thank you again for your work. Thank you for the presentation. We would ask that General Crump and his team come forward.
Thank you.
Next on our list. Good morning and welcome. And we're glad to have you, and we will, just in the interest of time, consider yourself overly welcomed and appreciated, and we'll ask you to get on with your presentation so that we can hopefully get back on schedule.
Thank you, Madam Chair. I don't think a lawyer ever feels overly welcomed and appreciated. But
We're
that
the
being said,
exception in this committee.
I understand. Thank you very much, Chair Lady Hazelwood and committee. My name is Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference. I'm joined by the two Deputy Directors of the conference, Brittany LaValle, who's the Director of Operations, and Mike Donovan, who is the Deputy Director for Legal Services and Policy. I'm also joined at the other table by Mike Huffaker, who is our Fiscal Director. Our motto for the last year has been every case, every day, and that is what Tennessee's district attorneys and their assistants, victim witness coordinators, investigators, and secretaries do. Last year, Tennessee's district attorneys and their assistants handled 944,996 cases across the state of Tennessee. Those are both felony and misdemeanor cases in juvenile, general sessions, and criminal court. Thankfully, over the last few years, the caseload number has dropped. If you will notice in the slide that is up there, not so long ago, we were at over 2,000 cases per assistant district attorney. Thanks to the General Assembly and the administration over the last few years, we've cut that number by almost a quarter to 1,700 cases, which is still much higher than the surrounding states, but it is much more manageable from a legal perspective. Those cases involve everything that you hear about in the news and many of the things you don't hear about. But part of being able to be successful in the courtroom is that we continue to maintain expertise in the divisions of the law, such as human trafficking, being able to charge second-degree murder for those who would deliver fentanyl to our people that die of overdoses, elder abuse, child sexual abuse, and then certainly a burgeoning area of our experiences in the recovery court, the veterans court, the mental health court, the diversionary programs that are giving so many Tennesseans a second chance. Our original budget increase request was roughly $6.5 million, $6,300,000. Of that, about $2,500,000 was related to our child support division. Tennessee's district attorneys don't just handle criminal cases, they also handle child support enforcement in 21 of the 32 districts. Those cases and those matters are handled by a separate division. The $2.5 million was requested through the Department of Human Services and the administration to provide salary increases for the child support division. We are incredibly grateful for the salary increases that you did for our staff on the criminal side last year. You changed the world for assistant DAs. And I hope that many of them have had the opportunity to reach out to you, and thank you for that. But the best tell of that is our attrition rate. And last year when I sat here to give this report, we had 89 vacancies across the conference out of roughly 1,000 people in our criminal division. As I sit here this year, we only have 50. And of that 50, 7 of those are what we would consider a ghost position that need to be abolished. And 4 of those are positions that are filled but have to or aren't filled because they are being reclassified. So in reality, you're talking about dropping well over half of our attrition rate in the span of 1 year. As General Skrmetti said, being able to compete in the legal market is extremely difficult. He is trying to hire people at a close to a 6-figure range. We're starting people in the mid 60s, but we offer something that most other law firms can't do. We don't tie them to a billable hour. We don't tie them to a client who tells them what is the right thing to do. They're allowed to go into a courtroom every day and determine what is the right thing to do. And while they may not get paid the same, there are many days that they won't be able to tell just how much they've changed the world. So that pay made an incredible difference. You also provide us with market rate adjustment funds, which we have greatly spread out across all of our other, besides our lawyers, all of our other positions, and we're seeing the same sort of results there as well. Also, we have asked for funding to replace 8 assistant victim witness coordinators. Our victim witness coordinators really are the hands and faces of the criminal justice system to so many of our victims. When lawyers are in court, the people who respond to the victim's needs are those victim witness coordinators. We have 34 across the state that are federally funded, and those funds are proposed to be cut by a quarter, which would mean the elimination of roughly 8 to 10 of these positions. We asked the administration in our budget request. It was not funded. We asked them to replace 8 of those with state positions. We asked for a market rate adjustment in our rent. As you all know, rent has become unbelievably high. I had no idea how high it was until I started negotiating rent for 32 judicial districts. It is incredible how much that has increased. And so we were fortunate the governor included that in the budget along with the service and experience credits. The last thing I'll talk about are technology improvements. We are in the last phase of rolling out to all 32 districts a unified state management system, both for documents and for case management. It's the Civic Eye system, Civic Eye platform. All 32 districts will be combined. It'll be a central network where we'll be able to, for you or any other inquiry, we'll be able to pull literally every criminal case across the state for either your statistical review or for any other kind of information that you might want. We're also in talks with the Sheriff's Association to expand that, to combine it potentially with the VineLink program that you all are familiar with. That would provide sort of a basis for a statewide case management system that has long been something that the legislature and the administration have looked forward to having. Of our technology asks, the 2 most important are the judgment portal. Our judgment portal will allow the electronic transmission of judgments instantaneously from the assistant DA that completes the case to the judge for electronic signature, and then immediately transferred to the clerk's office, the TBI, the Tennessee Department of Corrections, and Defense Counsel. This will greatly speed up the ability of people to know when somebody's been convicted across the state. It will create a much quicker transfer of this information, certainly between the clerks and the TBI and the Department of Correction. And Civic Eye, that's the last part of this. That's to bring our last 2 major jurisdictions, Nashville and Memphis, online. And so we're hopeful that either in the amended budget or through some action of the legislature, we'll be able to move that forward. We asked for 6 assistant DAs additionally. Last year, the General Assembly created 3 additional courts with criminal jurisdiction. We have, if there's a new court created, it's very difficult on an office to staff an additional court because, as you might imagine, 1 doctor in 1 operating room is fine. 1 doctor in 2 operating rooms is a bit of a problem. The same thing is true in courtrooms. And so we had asked the administration for 6 assistant district attorney positions, but that was not granted, and we'll probably be coming back for that at another time. I've already talked about the child support staff. We also proposed the only 2 sets of lawyers in the state of Tennessee that did not get a salary adjustment last year were Tennessee's public defenders and Tennessee's district attorneys. And this year we asked the administration to include in the budget a raise that would raise them to the equivalent of a TBI special agent in charge. We felt like that was a relatively modest ask in terms of the amount of responsibility they have compared with the Tennessee special agent in charge. And while we certainly don't, we're proud of them and we're proud to work with them and we appreciate very much the service they do. We have different levels of responsibility, but we felt like that was appropriate. That did not happen, and we'll be pursuing that further in the future. So with that being said, I know time is short. I'll open it up for any questions that you all may have.
Thank you, General. We appreciate your brevity. We do have a number of questions, and I'll begin with Chairman Hicks of Hawkins.
Thank you, Madam Chair and General Crump. It's certainly good to see you and your staff. Thank you all for being here. And I was trying to, I guess, follow along with the positions. And so I may have to back up before we can come forward to this year's budget. But let's go back to fiscal year 24, which is our current year. So $2 million was appropriated for 24 positions, and then salary equity was going to be used for 8 more positions. And so can you just tell me, I was trying to follow, but you lost me a little bit. So let's talk about those. Have those been filled yet?
Thank you, Chairman, for that question. 28 of the 32 have been filled. We began filling those in October of this year. And so 28 of those have been filled. As you might imagine, in rural jurisdictions, it's much more difficult to fill those positions. Even though they may have the need, it's much more difficult to convince somebody, for example, while it's beautiful to move to Tellico than it is to move potentially to Nashville. And so filling those positions sometimes become a challenge, but we anticipate by the end of this fiscal year that they will all be filled.
And then as far as the salary equity, how much was used? How much is left?
Roughly 86% was used of the salary equity. We reserved 14% for 2 reasons. Number one, we did not know what would happen within the child support sphere, and we wanted to make sure that we had potentially something to provide to those employees. But then also, we did not know what the outcome would be. Would there be market rate adjustment funds this year? Would there be cost of living increases? We wanted to have something in reserve so that toward the end of this budget year, we could take that place or fill it as we needed. But we used 86% on the front end.
Okay. Thank you very much, General. Thank you, Madam Chair.
Chairman Williams.
Thank you, General. Thank you for coming. The back to what Chairman Hicks was saying, we did market rate adjustments as well in the last calendar year. I guess the question for me is, have you noticed you've been able to move the needle as it relates to those market rates? Are you more competitive in the marketplace? Is there still more needed in order to be competitive in the marketplace? If you could answer that, it'd be great.
Thank you, Chairman Williams. Absolutely. I think on the support staff side, we are very close to parity. Certainly within state government, I think we're in parity with state government. With the private market, frankly, I think we're in as good a shape as we could be. I think that we offer things that the private market can't, and so I think we're extremely competitive. As General Skrmetti talked about, though, on the lawyer side, that's always a challenge. And frankly, unless you all were willing to start assistant DAs at $160,000 a year, there's no way that we'll ever reach that. We have to reach them by giving them a cause. We have to reach them by giving them a better life, work balance. We can't offer them work at home. We can't offer them AWS or anything like that. So we have to give them other things. Certainly, I think we have to do a better job as a conference of keeping you all aware. I think the problem was not with the General Assembly, to be fair, and this is not to criticize my predecessors. I think it was that we did not constantly have a plan for updating lawyer salaries. And so when we had to come to you, we had to come to you with a large number. And our promise to you is that we won't ever let that happen again. As we see these salaries start to creep, it's our job and frankly, our goal to make sure that we move forward and get those to you. But I believe we are competitive and we are currently, we believe, in a good space.
Okay.
Chairman Williams.
Thank you. As of Monday, the conference had about a little over 55, I guess, 57 vacancies. Of those, 21 of which you've had for more than 12 months. The reason for the previous question is really to find out if we're competitive. Is it that there aren't enough people to hire? Is that why you're carrying these vacancies? And what is the driving force behind it if it's not pay?
Thank you. I think there are 2 things in play there. Number one, we have a number of these positions. As I said, of that number, currently, according to our management system today, there are 50 there are 50 positions that are unfilled. We checked with our HR department this morning, and so there are 50. Of those, 11 are either reclassifications or they are positions that need to be abolished. So we have 39 across. In terms of the year, we went through and tried to abolish all the ones over the last year, or at least identify the ones. We have a number of positions that used to be filled, for example, by a drug task force. A drug task force, we created an assistant DA position that was funded by a drug task force. And then they stopped funding it, and there's not a person in that. We don't believe that there is any systemic problem with those. We're in the process of going through and identifying all those that either need to be reclassified or those that we frankly need to go beyond the 7 we know that need to be abolished. We think that's probably where those numbers come from.
Okay. Thank you.
Representative Timothy Hicks.
Thank you, Chair Lady, and thank you for being here, General. Especially like the work that you do in the recovery court. That space is well needed and changes a lot of lives. Thank you for that. To sort of tag on to Chairman Williams, the proposed budget includes a reduction of about 26 full-time positions and 6 part-time, non-reoccurring positions from within your office. What precisely are these positions? How were they funded? And how will their elimination impact your agency?
Well, to be honest, as we went through the budget documents, we only realized this morning that there was a proposed cut in our positions. So I can't tell you the answer to that, but I can tell you that as we stand here today, any district that loses an assistant DA would be greatly harmed. Any position, we're not overly staffed. We are in a position that we are constantly trying to find ways to leverage technology so that our people have more time in the office to prepare. We can't afford any cuts in people. We can afford cuts in lots of areas, but as I said, and this morning was when we realized that there was a potential cut of 26 positions, and that would greatly change. Certainly, depending upon the mixture, it could greatly change and greatly harm the delivery of criminal justice services in our trial and general sessions courts.
Did you have a follow-up, Chairman? Representative Shaw.
Thank you, Madam Chair. Thank you for being here. I just want to briefly say I appreciate all the work that y'all do, and I think sometimes we probably take for granted how much you do for our communities and for our state, and we really appreciate that very much. I wanted to just move to another area, an area that's always been a passion of mine, it's not a criticism about the law itself, but why is it that when you talk about expungements in Tennessee, every county seat has a different answer? And you talked about the technology of bringing things together. Maybe you've answered this. What can we do that if I qualify for an expungement, it should be the same in Bolivar as it is in Somerville, if that makes sense?
Yes, sir, it does. And thank you for that question. I think there are a couple things that factor into that. The first is the lack of necessarily communication between jurisdictions. That's part of why both the General Assembly, the administration, and frankly, all of us in the system want a unified system. You have 2 systems, and for example, in the court clerk's offices, some people are on what's called the Tensis system, some are not. And then I think there have been so many changes to the expungement law. Every year there was a change. I think there are a lot of people who just haven't kept up with the changes. And when they come to our office and we're asked, certainly we should be able to give them the answer. And my hope is that we're giving them the correct answer. I apologize. But I think the biggest problem is there have been a number of changes. And as each year has added a layer or a change to what had been done before, there just haven't been some folks who have kept up with it.
Representative Shaw.
Thank you. And I realize that you've already got a load on you, but I mean, is there any way going forward we can unify that where each county seat, if you will know what those changes are, because again, I don't want anybody to be expunged that don't need it, but if they deserve it, they shouldn't get one answer here and one answer there, because we've had a whole lot of clinics try to help people, but and like you said, the law has changed, so each time it's so different, and that's the frustration that I've had. Yes.
I think one of the things that we could do is work with the AOC, and certainly I'll reach out to my companions over there and ask them to engage in this conversation. And perhaps we could, after this, we could come by your office and talk with you more about it and see where the solutions might be.
All right. Thank you, sir, and thank y'all for being here. Thank you.
I think, that won't be the first time that situation or similar situation, having the law is one thing, having it consistently applied is another. And I think it's an ongoing challenge. Representative Gant.
Thank you, Madam Chair. Good morning. Thank you all for being here. My question is surrounding the open container law. And it's my understanding that part of the reason why we still have this law on the books is that partially funds the assistant DAs. Is that correct?
Thank you. Yes, it does. There are federal funds that come in as a result of that. There were, as I think you'll recall, there was a move a couple of years ago to change the open container law. We at the time worked with the administration, and the idea was if that passed, that the administration, I believe that was under Governor Haslam, would work with us to replace those assistant DA positions. And so the short answer is yes. The long answer is we've faced the elimination of that before, and the administration had been ready to pick it up. But that is the current state of the law.
Do we know the amount of money we're talking about that funds from the open container law to your DAs?
It's, as I recall, it's roughly $5.5 million. I'm not entirely certain of that number currently, but at the time it was about 5.1. And that funds both assistant DAs and it funds coordinators in each of the districts. Some districts have 2 lawyers, some have 1 lawyer and a coordinator. Larger jurisdictions may have other compilations. It really is probably more like between 65 and 70 employees that are covered by that amount. But those numbers also include training, not just for us, but trainings that go on outside. We have 2 people within the conference who routinely train the Tennessee Highway Patrol, local law enforcement, not just on what happens on the road, but testifying in court, prosecuting both vehicular assault and vehicular homicide cases. So there are training funds involved in that for the conference, for us to put on things for law enforcement, but then also for those positions.
Okay. Thank you, Chair.
Representative Barrett.
Thank you, Chair Lady. General Crump, how are you?
I'm doing well.
So you've given us a bit of a revelation this morning about positions being recommended to be cut. Can you give a little bit more explanation as to which positions those are? And where that I'm assuming that recommendation came from the governor's office with his budget.
Let me say this. This is my second year to do the budget. And the first year was much more exciting than this one. But last year, our budget also showed a proposed decrease in positions that when the final budget came out, we ended up losing no positions. And I can remember at the time, I want to say it was 19 or 18 positions last year that when the final budget came out, the number of positions we had were still fully funded. I first heard about this actually from General Scarametti as we were walking up. So I saw this before, and my suspicion is that it is the same thing. But I don't want to say that and then have to come back and say, hey, what I told you, I actually do need 26 more positions. My belief is that in the final budget, our numbers will remain constant. But I can't say that sitting here today.
So what is your understanding of the 26 positions that are currently listed as being cut? Are those ADA positions? Are they staff positions? Do you have any idea what the breakdown of that is?
I don't know at this time, but we'll certainly get back to you and let you know those numbers.
Please do.
Representative Barrett.
Also, on your slide, you had budget requests for additional ADA positions. I believe 6 ADA positions. And of course, I see the 23rd district, which is near and dear to my heart, listed in this. Can you explain what those positions are for? Staff, how you're going to break that down, and what was the reasoning behind that? I'm assuming there's data and whatnot that's backing that up as to why you're needing those positions.
Yes, thank you. Last year, the General Assembly created 3 new courts. And in each of those courts, we have to have somebody to staff them. We only do that. We only ask for positions if they're going to have criminal jurisdiction. And so the 2 lawyers in the 23rd were lawyers that would be specifically set to staff the new criminal division that was created in that jurisdiction.
Representative Barrett.
I'm sorry, Chair Lady, one more. And so this coincides with the discussion that we had during the 23-24 budget talks. The AOC recommended 5 additional judges be added. Only 3 were approved in that budget. And so coming forward, though, there's still a conversation about these 2 additional judges. So is there statistical data that you all are looking at as far as caseload and whatnot for those districts to support other staff requests that you have?
Yes, sir. We looked at those, and I don't recall the exact numbers from back last year, but the 3 jurisdictions, one of them is the 19th, which is one of the largest and quickest growing districts in the state. And they were really in a specific need. All across the state, we frankly could use more judges, not because the caseloads are unmanageable, but to change the speed at which litigation occurs. In my old home district of the 10th, I had 2 judges with criminal jurisdiction for 4 counties. They had roughly 38 weeks apiece in court. Well, if you take out non-jury days, you're really talking about less than 150 days total in trial. And with an average trial taking a minimum of day, maybe 2 days, when I was a young assistant, we could try 2 DUIs in a single day. That's no longer, we can't even pick a jury because of the way the law has changed now. And so you're looking at a maximum maybe of 75 trials in that jurisdiction in a year. While we may indict several hundred cases, maybe several thousand cases. And so we could use more judges just to speed up the pace of litigation. But in terms of caseload, obviously we're handling what we have. But anytime you want to deliver something in a more efficient and a quicker way, the more people you put into it, you just have to figure out where the balance is that you want. And like I say, I think we do a good job in the criminal justice system of getting and moving things through. I mean, we moved nearly 1 million cases last year. But by the same token, we should never say we're doing as well as we could. We should always do it better.
Thank you very much. Thank you for your time this morning. And Chair Lady, thank you for your patience.
Chairman Moon.
Thank you, Madam Chair Lady. Representative Barrett covered the area very well. Thank you.
Chairman Hawk.
Thank you, Madam Chair. General, thank you so much, your team. We've known each other for a long time. Just to follow up on something that was said, we mentioned that the laws have changed that have created some of the burdens on the court system. Have we passed the laws that have created these burdens, or are there rules that have changed? If we could get some clarity, is it something we've passed, or is it more so rules of the court?
Thank you, and that's a great question, and I could probably talk about that the rest of the time. I think it's more the professional character of litigating a case has changed. The ability for a client to sue a lawyer or otherwise make a complaint against their representative, their counsel, has changed dramatically in the last 25 years. Lawyers are much more frequently defending claims that they have not done their job well or not done their job correctly. Additionally, as lawyers have seen that, the courts have also made there have been a lot of changes in the requirements, the sort of the technical things for getting a case to trial. Once a case gets to trial, what do? There are many more jury out hearings where the lawyers come up and talk about something that didn't occur when I was an assistant. It was something that you just sort of move forward on. And so I don't believe it's the General Assembly that's done it. And I don't frankly think it's any one particular group. It's just the nature and the professional character of litigation has changed dramatically since I first started. And I think that's created this, it's odd. We've had this lengthening because of those things, but things like legal research now, what might have taken me 2 or 3 days in 1993 when I started practicing law might take me 2 or 3 hours now. Because computer research has become so much more advanced. But once you get to the courtroom and once you're litigating issues, it's much more tedious and slow than it used to be.
General, before we let you go, I just had a question regarding the victim witness coordinators. You mentioned that federal funding is being withdrawn for 8 of those. Do we have any indication, and I know this, you don't have a crystal ball, but do we have any indication from the federal government? Is this part of an ongoing wind down? Is this something that they're expecting either the state to step up to or these positions to go away? So next year, will you be in here telling us that now we have funding for 10 less or 15 less or whatever?
Thank you, Shirley. We just got back from Washington with the National District Attorneys Association, and that was one of the main topics. The federal or the Senate markup on the NOVA bill is $1.9 billion, which is its current funding. The Senate proposes to fund it at its current amount. The House has proposed $1.4 billion. We have heard for the last several years that this was an endangered grant system and that we needed to be thinking about what we would do. I really felt like that this would be wound down over several years, and that's the reason that we started with 8. We have 34. We believe we can get all of them done by the time that the grant funds are gone. If they come back next year and they say they're all there, great. But we wanted to be prepared. The position of the conference is for each of these that are awarded, if you're given one of these within the conference, you have to let your federal grant go. We're not adding to these numbers. We're simply trying to get them off of the ones out of the positions we believe may be eliminated.
And I guess that begs the question, is the number that we have now sufficient to do the job?
No. I say that only because, and I'll just tell you about, I had 5 victim witness coordinators. They each had cell phones, and they rang all weekend by victims. They rang at all times of the day, all times of the night. My victim witness coordinators went to General Sessions Court, and if they were helping with a victim in trial, somebody left what they were doing to cover their court. At 4 o'clock in the afternoon, when court would conclude, if it got through that early, they'd come back and they'd start doing their letters. It used to be, when I was a young assistant DA, that the lawyers were the last one in the office. Now the victim witness coordinators and the lawyers are there together. And so, are we doing the work? I am incredibly proud of the work they do. But they are swallowed up. And so, while yes, they're doing the job and they're doing it admirably, they could use help.
Thank you for that. And again, we're past time, but we appreciate your willingness to wait earlier. And we would, again, just express our appreciation for the work that's done across the state. You know, we put laws on the books, but you guys are charged with enforcing those. So thank you for your diligence in doing that. And now we would ask our Public Defender Conference, Director Frog, if you and your folks would come forward. Good morning, Director, and thank you for your patience. Are you looking for more moral support there? Good morning and welcome. And again, we will dispense with a lot of the niceties, and just in the interest of time, ask you to get straight into your presentation after you introduce those folks who are here with you this morning.
Happy to have her. To my left and to my right is Chelsea Curtis. She's the deputy director. You'll see her running around up here if you haven't already. I also want to just for a moment tell you I've kind of got a little cheering section here. There you go. All right. Sorry. I'm not going to go through that again. I think you could hear me. But we also have a little cheering section here. I do have 3 elected district public defenders here. Andrew Gibbons from the 2nd, Todd Estep from the 3rd, and Becca Lee from the 4th. Some of you know them because that's where you're from. If you don't, that's Upper East Tennessee. The 4th, Sevierville, is kind of interesting. They're sometimes a very small rural community and sometimes the biggest city in Tennessee, depending on the season. So that can be challenging. You know, I always struggle, and I feel the urge to give you all a PowerPoint. But the truth is, our budget, one of the things about it that's nice, for me at least, is that it's incredibly simple. We do really one thing. You know, we defend poor people who are accused of crimes all over Tennessee, and it's 99% state appropriation, excuse me. There's very little revenue that goes in. There is some local money here and there, but it's mostly state appropriations with a pretty clear mission. The budget is about 90% payroll and benefits. So the 10% that's left, that's discretionary, is mostly rent, copiers, legal research software, and the like. So it's a fairly easy budget as far as state budgets go to comprehend and to see what we do. We're very transparent. I can go through the budget document that was the administration budget that was released Monday night, included what the district attorneys told you. There are really 3 things that are statutorily required. One is our pay and experience plan. We have a statutory step raise plan that's statutorily required. There have been 2 years where during lean times we didn't do that, but this year that's funded. And the second is the way that Memphis and Nashville are funded. They do receive state funding for their public defenders, but it only accounts for about 25% of their budget. So the 25% number is just what happens. That's not by statute. The statute requires CPI to govern. So every year we get like a block grant basically that passes through my office to Shelby and Davidson, and that becomes relevant in a minute. You know, as we were going into the budget season, I represent a bunch of elected officials. They're all elected for judicial districts to be public defenders, but they understand the hard realities of state budgeting. And we were told this would be kind of a tough year. Revenue's down, things like that. And we want to be good stewards and we want to be good citizens. And so we initially thought we will request what we can just barely get away with. We weren't going to request many positions. And the budget deadline was on a Monday. Tuesday night, I couldn't sleep. And so Wednesday morning, I got up and called F&A and said, I can't do this. You know, we have a caseload crisis in this state. We have had the public defenders, the district public defenders are now so understaffed, they're used to it. And that's not serving citizens. We are in an adversarial system. We have to be funded too. And so I got up Wednesday and amended our budget request and added the positions for the districts that I thought just had to have it. And I think that's why we've got district public defenders here. I think, you know, they want to emphasize that they need staff, and this isn't for luxury. This isn't for sport. I personally believe the DAs need more staff too. And if you don't believe me, walk into a general sessions court in your district. if you're a victim, if you're a criminal defendant, I don't feel like on either side of the aisle, you're probably getting the attention that you would want. So that's why I keep requesting positions. You all have been very good. And the governor's office has been very good at each year giving us positions and letting us fill in where we can. And I understand this is a tough year, but I wanted you to know I'm not asking just because that's what we do. I'm asking because I think we need it. I leaned back while we were listening to the prosecutors to Todd Estep in the 3rd district and said, Todd, how many lawyers in your 4-county district? And he said, there's 10. And I said, what do the standards say that you need? And he said, 20. He's asked for 3. So we're willing to work hard. We're willing to work long hours. We're willing to really do our best. But we need positions, and I'm going to emphasize that really anytime I have a microphone. I will also say we did ask for funding, supplemental funding for Shelby County. Last year, this body was very good to us and gave our assistants a long-needed pay raise. That helped our offices. It's going to help turnover. It's going to help employee satisfaction when we ask them to do too much. But the problem is with those county offices, Nashville and Memphis, they didn't get a pay raise. Their pay was governed by CPI. Now, they staff their districts differently. They're on different pay scales. And when the Memphis public defender called me and said, I really want to seek this from the legislature, I said, go to your county first. And she really did. She got everything she could out of Shelby County. And so I put a request in to equalize their pay. And I believe there will be a bill coming to that effect as well. And finally, we also did request, one of the things great about Tennessee is that public defenders make the same as prosecutors statewide. That's important. It means that, in some places, I know some rural places where that doesn't happen, whoever makes more, they run to that office. So that keeps turnover low. So the prosecutors and we agreed to also seek the pay raise that General Crump talked about for the electeds to put us on the same level as the special agents at TBI for our elected public defenders. So that's really all I have. That's the request. And I'm happy to take any questions.
Well, thank you. And I have visited General Sessions Court. The judge that I sat with welcomed me to the ER of the criminal justice system, and that's definitely what it was. It was an eye-opening experience. So, and there was so much going on with attorneys swapping out clients and all this. So I can obviously understand that it's a hectic situation, certainly there, and probably in other courts as well. And I know that we've had conversations with the AOC's office and other folks. We have a situation when you all cannot defend for whatever reason someone who is indigent, then we're not being able to pay attorneys anything like a competitive rate to take those cases, and it's getting very difficult, I know, to find other attorneys to represent folks who can't hire their own. So it is an ongoing problem. With that, we have questioners on our list, beginning with Leader Cochran.
Thank you, Chair Lady. And Director, thank you for being with us this morning. Wanted to touch a little bit about on some funding that we appropriated last year and wanted to dig into that a little bit more. So in fiscal year 23-24, we appropriated $2.4 million for 22 positions. 7 of those were social workers, 15 other positions were to handle increased caseloads. So authorization was also given to establish a human resource manager to be paid out of salary equity. So just to touch on a few of those, at this point, how many of those 22 positions have been filled?
They've all been filled. I think we may have had turnover in one. It may be that one employee didn't work, or maybe more than one employee didn't work out, but we filled them quick. We'll fill any positions you give us.
Awesome. And so the social workers, human resource managers, all those spots have been hired.
Correct.
Awesome. And then, Chair Lady, just one more. And then how much salary equity was utilized, and how much salary equity does the conference currently have?
The current numbers I've seen are about, it's sort of in flux because we're actually counting it right now from the last month, but I'm going to call it about $750,000 in terms of what we currently have. I think she's editing me in her head, but that's what I feel comfortable committing to right now because it is in flux. And the second question was, I'm sorry.
So salary equity, how was that? How much of the salary equity was utilized?
So I don't have a percentage on the salary equity, and I want to make sure we're talking about the same thing. There was market study money that was appropriated last year, but salary equity is a moving target.
Okay.
We utilize it, as quickly as we can. One of the ways that we can do that is if you all or the administration adds positions into the budget, but doesn't fund them,
Sure.
but allows us to fund them, we can do that. We've used. I don't believe we have a problem of unused resources. If you give it to us, we're going to use it.
Okay. Thank you very much.
Chairman Whitson, you're recognized.
Okay, thank you, Chair Lady Hazelwood, and Director, good seeing you, and thank you again for your help with the challenges of renting space in downtown Franklin near the courthouse. And I just want to tell you, Greg Burleson and his team do a great job for the citizens of Williamson County. I just want to say that. Real quick, in the FY 23-24 budget, and we've heard this from every other presenter before you, is the competitive salary challenges for district attorneys and, assistant district attorneys and the investigators. Are your pay schedules now competitive across all positions with the increase that we made into the 23-24 budget? If not, what more is needed, sir?
So I think you're referring to the market study money that was appropriated. Yeah, that has helped. Of course, it's different in different locations. Money goes a little further here and not as far there. But yes, I think given the pay raise to our assistant the lawyers last year, and the market study money that allowed us to raise secretaries and office managers, I would say, yes, we are competitive as long as we stay competitive within the judicial system. And we are now with the district attorneys, with the judges, secretaries, and the like.
And one more question. Yes. And what was the range of increase for assistant district public defenders and the other staff? Do you have that information?
Yeah, I think it was really 15% across the board was the raise that was appropriated last year. The other staff ended up being more like 10%, but that was because in prior years, market study money had put them higher than that. So we dialed it back a notch for them.
Okay. Thank you, Director. Thank you, Chair Lady.
Representative Barrett.
Morning, how are you?
Good morning.
I want to direct your attention to a questionnaire response, particularly regarding some 20 total vacancies, I think, that were listed. They're revenue funded. I think 15 of those are revenue funded positions. 10 of these positions have been vacant for longer than 12 months. So my question is, what is the source of the revenue, which fund these positions? And then is it a reliable source?
Right. So anytime you take a snapshot of our agency, I expect you will see 5 vacant positions, but none of them are ever long-term. That's just, an agency this size, that's about how many sort of the churn operates. So that accounts for those. As for the revenue funded, there's a statute that allows counties to impose a local tax. It's a state tax, but it's collected locally. We call it the 1250 tax because it's a $12.50 tax that goes on to court costs. And that funds our agency. Lots of counties, I think about less than half, collect that. And where we've used that to establish positions, we found it to be very unreliable. For example, in COVID, collections were cut in half on that because it's, people stopped going to court, they stopped paying their court costs. So where possible, I've been moving those into state positions as quickly as I can because I view that as unreliable. Those positions are long-term vacant because we don't have the money. So they're just sitting there not being used. But if somebody gave me the money, I'd fill them quick.
Thank you, Chair Lady. So the fee, the 1250 that you're talking about, is not mandated across the state. That is a local option for the county in each of the 95 counties to be able to choose whether or not they're going to collect that at the local level.
That's right.
And what level of influence or what type of campaigning has your office done in those counties to try to make sure that that gets maybe more widespread across the state?
Absolutely. I don't campaign for that. That's a local decision by the district public defender. Some of them are philosophically opposed because it adds court costs onto everybody, including their clients. Some have done it. There are maybe people in this room who opposed it until they couldn't anymore and realized they might be able to fund a secretary out of it, and they desperately needed one, so they went after it. You have to convince your county commission to impose it. And lots of county commissions don't want to impose taxes. They don't have to, but where it gets desperate, they'll do it.
All right.
But I don't engage it. I don't try and convince county commissions to do that. That's up to the local elected public defender and dependent on the jurisdiction.
Thank you.
Yes, sir.
Chairman Hawk.
Thank you, Madam Chair. Director Frogue, thank you very much. We've known each other a long time as well, so I appreciate that. Inherently, many of us are problem solvers by nature, and as we're talking about staffing issues, I heard an interesting issue from the three PDs that came to visit from my region yesterday, and one of those concerns was about death penalty cases, and specifically the resources that they need, all resources across the board, but mainly in experienced attorneys to help defend these death penalty cases. And I'm reminded of a budget hearing we had last month with the Post-Conviction Defender's Office. Brainstorm only. Here's an idea. What happens if we create through your office a pre-conviction defender office on death penalty cases specifically? Not sure how broad and wide those cases are and how many of those cases each district have over the course of a year, but what would it look like if you've got 505 positions now, what if we add 25, 30 positions to your budget and have those as freelance attorneys to go provide support to work within those judicial districts with your colleagues who know those districts? Just an idea, what would that look like?
Thank you for the question. I think it's a good idea. It's an idea. There used to be a capital branch of the District Public Defenders Conference way before I got here. I think they ended around 2011, 2012, but I spoke to one of the lawyers recently who used to work in that. And she said, we didn't really do much because all we were was education and training around that. And the lawyers didn't have time, they were in court. So I think if we were to add a division of a handful, however many lawyers who traveled the state and engaged in death penalty defense, I think that would be a great relief to the districts, because those cases do suck up an enormous amount of time. I mean, there's a Supreme Court rule that says one lawyer can't do one. Got to have two. They've got to be specially qualified to do it. It typically involves expert testimony. There are complex mental health issues in a lot of those cases that have to be litigated. I mean, they have to be litigated. If they don't get litigated here, they're going to get reversed in federal court. So I think that's a real good idea. I'd be interested, of course, the devil would be in implementation and how you do it, but I think that's a very good idea.
Chairman Faison.
Thank you, Madam Chair. And I don't have a question for Mr. Frogue, but I do have a personal privilege. My public defender, who I personally believe to be the very best public defender in the whole state of Tennessee, also goes to church with me, is here. That's Becca Lee. Y'all make her feel welcome, please.
Chairman, while I'm sure that she is a wonderful public defender, I have to speak up for my own, and we will have to, I'm sure other members may feel the same way, so we may have to hold that designation for to be determined later. Representative Sparks.
Thank you, Madam Chairman. I want to go back to Johnny Shaw's question. He talked about expungement. A few years ago, we hosted an expungement clinic at my church, Parkway Baptist, and my public defender, who I think is probably the second best in the state, behind this young lady, Gerald Melton, great guy. But your office was there, Ms. Curtis was there. I think your judicial, bus was there that they came, and tried to help a young man. Well, he's about 40, turned his life around, had a terrible story, 18, 19. Dad, I think, died of heroin. Mom committed suicide. They just weren't able to help him. And I felt like there was a disconnect maybe between the DA and and that. So what else can we do, or what else can the clerks do and the DAs to seem like communicate a little bit better? Because it's kind of based on a freedom issue, I would think. Um, I'm not an attorney, but did speak at the Board of Probation Parole for Justin Bashir, who turned his life around, was in trouble at 18, 40 years old, now a minister, true craftsman. They recommend a full pardon for him. But when we see workforce development and people that made a bad mistake when they're 18, 19, 20, they turn their life around to 35, 40, 50, just seems like it just makes sense to try to help these guys that have proven themselves to be productive citizens, have paid their debt to society, to kind of move on. But what else can we or the whole system do to communicate a little bit better? Because there may be a disconnect from the 23 different branches that's out there.
Yeah, I really appreciate this question. I think, I can talk a lot about redemption and I can talk a lot about second chances. Obviously, it motivates me and a lot of people who do this work. But what this body, I think, could do is simplify the expungement statute. If you didn't change anything about it, if you left the expungement statute exactly as is, that is, the things that are eligible are still eligible and things that aren't still aren't, but made it able to be read, clean, I think that would go a long way in helping people. One of the problems now is, the justice bus that AOC runs,
Yes.
they do expungement clinics. Our district public defenders, when they have time, which is rare, do expungement clinics. That statute's incomprehensible. And it's only because for a good reason, we keep adding to it. Excuse me, you all keep adding to it. And so every year there are new things that are expungible. Maybe something gets taken off, but it's very difficult for almost any lawyer, much less a layperson or a clerk or a legislator, to read that statute and be able to tell you what's expungible. So I think a clean version of that would go a long way in easing those communication problems, because really the communication problems, I think I was at that expungement clinic with you, and it got overwhelmed with need, and I tried to jump in and help, and I kept having to ask her what the law was because it was very difficult to figure out.
Yes. Well, let me ask you, there's a book of lobbyists. It's 58 pages, 300 something lobbyists. Is there one in that entire book lobbying for this issue that's about freedom? I don't think there is.
I don't
think there
want
is.
to. I'm thinking of a couple, but I'm not sure they're lobbying that issue right this
Yes.
minute. So I don't want to speak for
Just
anybody.
thank you. Just want to remind this committee about that. Thank you.
Thank you.
I don't have any further questions on our list. Again, thank you for being here today and spending the time with us and being patient to wait your turn. And again, we do appreciate all of our public defenders across the state. We will have that. I guess maybe we can have some sort of contest later to anoint the title of the best. But they all do a great job, as do their staffs. And I think we all are aware that the workload is very heavy. And whatever we pay them, I'm sure all of them could make more in the private sector. So I think in many ways it's a calling as much as a career. So we appreciate you all and the work that you do and the people that help you do it every day, because we want people to be treated fairly in our justice system. We want people who do bad things to be punished appropriately, but when they pay the price, then we'd like for them to be able to move on and be productive members of society. And we never want someone to be incarcerated or found guilty of something that they didn't do. And you guys are the line of defense to make sure that doesn't happen when people are charged and they don't have the funds to seek private counsel. So I thank you again for all of that work. And we will take your concerns under advisement. It is a tough budget year, and that's going to make it more difficult than perhaps it would have been at another time, but we heard you. Thank you all for being here, and we will ask next that our excuse me, Administrative Office of the Courts, Director Long, if you would come forward with your team, please, ma'am. Good morning, Director, and welcome. Before we let you get started, I do have a member, Representative Barrett, who had asked for personal order.
Thank you, Madam Chair Lady. I just wanted to acknowledge in the crowd, we're all very familiar with the head of the Sheriff's Association, Jeff Bledsoe, but the man who made Jeff Bledsoe's sheriff's office work in Dixon County is in the crowd. So he's now the chief of police for the town of Burns, Mr. Jerome Holt. Want to welcome him.
Thank you for being here today. I know our Sergeant at Arms appreciates the reinforcement in this rowdy crowd. He might call upon you at any moment. So, but welcome. Director Long, if you want to just go ahead with your presentation and we will ask our questions. We are scheduled to finish at 10. We have a little bit of latitude in that the room is not going to be used until 10:30, but I know many of us have other committee assignments. So we will ask that you be as brief as possible, and we'll ask our questioners when it comes time for that to brevity would be greatly appreciated. So Director Long.
Thank you so much, Chair Lady Hazelwood. We appreciate the opportunity to appear today. Let me introduce a few people. First of all, I'll introduce myself. My name is Michelle Long. I am the AOC Director, Administrative Office of the Courts Director. To my right is one of our legal counsels at the office. He is also the lead for our indigent services team. He and his team are responsible for kind of reorganizing the way we manage claims payment to get our turnaround time on payments down from, I think at its worst, about 3 months down to 30 days. So I am delighted to have him on our team and here today to answer any questions you have about the Indigent Representation Fund. Also, Dalton Hensley, who is our fiscal director at the AOC, and Brandon Bowers, who is our director for Information Systems Technology. So I will be brief and I will probably flip through some slides pretty quickly, but I cannot not recognize the head of the judicial branch for the state of Tennessee, who is our Tennessee Supreme Court. Chief Justice Holly Kirby is pictured there in the center, and the rest of the members. And I also wanted to highlight that earlier this year, Justice Page, who has served on our trial courts and appellate courts for over 25 years, announced that he will be retiring effective August of this year. We will miss him dearly, but we welcome the opportunity to, after you all confirm her, to welcome Judge Mary Wagner from the Shelby County Circuit Court to ascend to the highest court in the state. So very quickly, before I jump into our budget presentation, we were fortunate last year to get the support of the legislature really for 2 years for the court's desire to advance technology throughout our court system. We started with about $1.5 million in FY23 for a consultant. We hired the National Center of State Courts to come in and help us what we thought was just accelerate the implementation of e-filing across the state. And we have about 25 courts or counties that are e-filing, and some level of court in those counties is e-filing. What we learned from that work was that we need more than just e-filing. It's a broader approach in order to get to the robust type of system-wide data and reporting at a reliable level that we all need as stakeholders in our justice system. So that report recommended some things, the first of which was that we develop an infrastructure for this work. Under the leadership of Justice Sarah Campbell, we have now, the court has developed a Court Technology Oversight Committee. You see the members listed there, but we were intentional about making sure we selected clerks of our courts across the state and then representation from every level of court. One of the major initiatives that will be under the oversight of the Technology Oversight Committee is our statewide court information system solution. That's what we're calling it right now. It may change names at some point, but ultimately, this is the broader approach to what we need in order to get to the type of reliable data that we need across the system. It involves case management systems across the state, document management, and breaking down the silos, because currently most of our trial courts are funded for their case management system at the local level. So that means they've had autonomy in the vendors that they choose. Those vendors are not integrated. They do not speak to each other. For the majority of our counties, about 87 counties, are on a product that is a contract with the AOC, and that is the Tensis product. That product is highly customized. We learned from county to county, court to court, and it also is not integrated with those other vendors. So our goal is to bring this into one large integrated solution. So some of the products that exist today, to the extent that they can communicate with other products, they can stay a part of the solution. But we need all of those case management systems to communicate one to another so that every court record and all of the information maintained on a court record is reportable at some level. So we are partnering with STS for this work. We are also engaging with Gartner and Associates, who has done work in the state for other large technology development and implementation across the state. And ultimately, the value for us all as stakeholders and justice partners is that reliable, robust judicial branch data that will help us make better informed decisions driven by data. You will be seeing the release of a strategic plan relative to this work that will provide the transparency that we want to make sure we always provide as we go forward as a court system in this work. So that will be coming to your inboxes here shortly. Now, so let me jump into our budget requests. So, of course, we start with the statutorily required COLA for our judges. The next request is 1.6 million roughly for 4 new state trial court judges. A portion of that was funded by the administration. And then we had a $26 million request for indigent representation. And I appreciate Chair Lady Hazelwood's comments to the Public Defender's Office about the importance of that work when the Public Defender's Office is unable to provide the representation. And then 2 new positions for the AOC, which I will talk about later. Those last 2 items were not included in the governor's recommended budget. So if you will indulge, I will talk a little bit more about that. So in the governor's recommended budget, the 18th Judicial District was included. So what you see here are the other 3 districts. The 4th Judicial District, which is Cocke, Granger, Jefferson, and Sevier counties. The 19th Judicial District, Montgomery and Robertson counties. And the 23rd Judicial District, which is Cheatham, Dixon, Houston, Humphreys, and Stewart. We have tracked the weighted caseload study for a number of years to determine judicial need. There was some disruption during COVID to the comptroller's ability to continue to produce that report. But in the 3 years prior to COVID, each of these districts showed a need for 0.5 or greater judge. That's half a judge or more. And that's the parameter that the comptroller uses to determine that there is a need. So you'll see in FY 19, 18, and 17, each of those districts showed sustained need. We then took the formula that the comptroller uses and the same data to do a provisional kind of monitoring of judicial need during this period of time that the comptroller has not provided the weighted caseload study. And you will see in FY 23, the italicized numbers represent the fact that there is still sustained need in those judicial districts. So we strongly urge the support of the legislature to fund those additional judicial positions. The next request was roughly 26 million to increase the attorney hourly rate for indigent representation. We recognize that that may seem like a large number to some, but it's actually pretty conservative based on the 2017 task force report that recommended that the rate for attorneys should be somewhere between $75 an hour and $125 an hour. The court's approach is a conservative approach. We hope that it will assist our courts in getting private attorneys to take these cases. The longer and the more protracted this issue is, the harder it is for courts to get private attorneys to enlist in this work. The rate that we currently pay is $50 an hour. It has remained unchanged since 1997. Every judicial conference, as you will note from the slide, has lent their voice, their influence, and I'm sure you're hearing from attorneys as well. But for us, it's about the court system and the ability of the court system to run and operate efficiently. And you will see that our general sessions judges, juvenile judges, as well as our trial court judges all agree that this is approaching a crisis level in the state. We ask that you would help us by restoring that request or some portion of that request to the budget document. You will also note that, and what's important about this slide is really that we're talking about more than just adult criminal defendants representation. We're talking about children and families. We're dependency and neglect cases, the need for guardian ad litems to represent children in court, termination of parental rights cases where children languish in foster care while adoption proceedings are ongoing. Most of those start with the termination of parental rights. And the parties in those matters are entitled to representation, either by statute primarily, but oftentimes by constitution as well. So again, we would strongly encourage and welcome the opportunity to have more conversation about that going forward. Lastly, the two positions that were in our budget request that did not get funded are for the AOC. So we have two staff persons who are responsible for all of the HR matters for over 600 employees, about 668 people. That says positions. We have more positions than that, but 668 people. So you can imagine that is very transaction intensive. There's always a need for insurance. There's always a need to discuss retirement or hiring and firing. So there's very little opportunity for us to have the type of leadership that, say, DOHR has relative to strategy and how to make sure we are remaining competitive to attract and recruit and retain the very best and brightest. So we're just asking for one position to help us bring that level of expertise to the judicial branch. And then the second requested position is one we requested last year as well. You heard Public Defender Frog talk about the Justice Bus. And Representative Sparks mentioned our Justice Bus. We were at that expungement clinic that he spoke about. We got the Justice Bus with grant dollars, not knowing, if you build it, they will come, and they have come. The Justice Bus every year is engaged across the state in many, many clinics and opportunities to bring legal representation, because we partner with the Public Defender's Office, we partner with legal aid societies to bring legal advice and consultation to where the citizens are. And I think last year held over 30 events. And that is literally across the state. We have never hired people for that work. We've done it with our existing staff. And now we're asking for one position to help us increase our ability and our reach to citizens in Tennessee, as well as alleviate this burden from our staff that are engaged in other things. We didn't know how well this would take off over time, and it really has become a vital tool in communities across the state. So with that, I will turn it back over and be happy to answer any questions you may have.
Thank you, Director. There's quite a bit to assimilate there. I do have folks on my question list, beginning with Leader Cochran.
Thank you, Chair Lady. And again, appreciate your testimony with us this morning. Wanted to touch on something that you talked about a little bit earlier on, your investment in technology, the General Sessions data repository. And so last year, when obviously you fill out a questionnaire before you come here, one thing that you stated was that phase 2 of that project was 50% complete with an anticipated completion date of June 2023. And so this year, as you know, we're filling out that same questionnaire, you stated that the project is 65% completed, with the completion date now anticipated to be December of 2024. So if you don't mind, provide the committee an update on that project, and then maybe just some details on maybe what has caused delays.
Oh, absolutely. Thank you for the question. And I may have to phone a friend, but what I can tell you is that phase 1 was the General Sessions Data Repository is built on top of our TNSYS case management system. And so for those 85 counties and the courts in those counties that are on TNSYS, phase 1 was completed, no problem. That's data we have. It's already mapped, or it's already formatted for the General Sessions Data Repository. In phase 2, we have counties that are either on homegrown systems or a separate vendor-supported system. You'll recall I said that counties have made these decisions at the local level. So getting those counties and their vendors or their IT departments to prioritize getting their data in their systems into a format that matches the format in the General Sessions Data Repository has been a challenge. And it is truly about the resources that they may or may not have at the local level, and the prioritization of this work. So we're pretty much at the mercy of those vendors or local IT departments to help us map the information, then we validate the information, and then it goes into production.
Just one follow-up.
Leader Cochran.
And then my follow-up is about the funding of phase 2. And so it's funded with a recurring $1 million appropriation. And at this point, phase 2, I believe, has spent 90% of the project budget, but as we mentioned earlier, only 65% complete. How much do you anticipate in funding would be needed to complete the project?
So I think I'm going to turn to our IT director, Brandon Bowers.
Good morning. At this point, I would not anticipate an increase in funding. I think we can complete the project as it stands with the current funding in place.
Okay, thank you. Appreciate that.
Sure.
Chairman Zachary.
Thank you, Madam Chair. Good morning, Director. Thank you to your team for being here. Back to how you originally started your presentation, you had referenced the statewide e-filing system, the $75 million we had appropriated. How much of that $75 million is still available?
So the majority is still available. Before that, we had 1.5 million for a consultancy agreement. We have not yet spent all of that. The National Center was a discount, it turns out. And so we're still spending some of that fund to support the contract we're currently negotiating with Gartner and Associates. And so we'll start to spend that money here shortly, but we have not touched the 75 million to date. Most of that, it's one-time money, and we anticipate most of that being applied to implementation.
One more, Madam Chair. Chairman Faison had to step out, but he had a question with a little complexity to it, as he typically does. In 21-22 budget, we appropriated 1.5 million recurring for the juvenile justice case management system. 2 million non-recurring for the criminal justice data infrastructure. Have those projects been completed? How many counties are utilizing those projects? If you just give us a brief overview, please.
So I can definitely respond to the juvenile justice case management system. We have 51 counties out of our 51 juvenile courts out of 98 that are currently on the selected vendor, which is Quest, for the complete suite that Quest offers. We have another group of counties, I want to say 19, but someone here may correct me, that will be using the Quest data portal that the Tensis case management system is building so that that information can go in electronically into the Quest system, so we get complete juvenile data across the state. And then there are a couple of other little individual vendors out there, but about 4 counties have 2 other vendors. We'll be working to integrate that into the Quest system as well. The criminal justice data infrastructure project is not ours. We believe that it might belong to the Department of Corrections, but we tried to do a little history search on that, and I'll turn to Dalton Hensley, who can tell you why we believe that's not our project.
Sure, that money was miscellaneous appropriation, so it stayed with FNA and STS, and our understanding is that it was for a Department of Corrections project.
Okay, we'll engage them on that. Thank you very much. Thank you, Madam Chair.
Certainly, Representative Sparks.
Thank you, Madam Chairman. In fiscal year 23-24, the budget appropriated $4 million for non-recurring grants to reimburse counties for the purchase of equipment related to courtroom security. Do you know how many counties have applied for that grant, and were they sufficient to meet the needs of those counties?
So I can tell you that we received over 7 million in requests for the additional 4 million. So the need is great. We're in the process of determining, based on the committees, there's a courtroom security committee for the trial judges across the state. We're in the process of prioritizing and figuring out how to spend that money as equitably as we can, given that the need is over 7 million and we have 4 million to spend.
Yes, I'm also going back on Representative Shaw's request about expungement. On the unified court system, that's what you're talking about, that the Department of Corrections is more responsible for? Or is that, do you know where that's at?
You know what that is? Are you speaking about the item that we just said we believe belongs to?
That's what I'm asking you. I mean, is that the same request you're speaking of?
We don't have any visibility to what that is.
Okay,
It's
okay.
not our project.
Okay, thank you, ma'am.
Chairman Hicks.
Thank you, Chair Lady and Director Long. Thank you for being here. You mentioned the indigent fund just a little bit ago, and so just to kind of drill down on that a little bit more, I've heard from, strangely enough, judges who've reached out to me, and so Judge Walden back in the 8th Judicial District has reached out to me and telling me how important it is. But can you talk a little bit more about that? We had the public defenders. So walk a little bit through, how does a potential client end up with the private attorneys? Can you talk a little bit about that? How's that even happen?
So I think that Judge Walden, who graciously provided a letter, I think, to your office in support of this need, gave a great example. In his court, he's a criminal court judge. He may see, and he says he tries, or there are a number of drug cases in his court, and those cases may have multiple defendants. So the PD's office would be conflicted from representing all of those defendants. It's a great example of how this works in the criminal courts. For juvenile matters, the PD's office isn't involved at all, so it is all done through the Indigent Representation Fund that we manage at the AOC.
And so in his letter, Judge Walden, he pointed out that with what these private attorneys are getting paid, which is about $50 an hour, that's about 25% of really of what they should be getting paid because of the overhead that comes with this. So I think that is certainly something to, to consider. And yeah, as we work through this request. But this year's the carry forward was 10.4 million from the fund. How much of the 44.8 million in funding is utilized in a fiscal year?
So prior to COVID, every dime was utilized to pay claims. We did not experience excess funds in the indigent defense allotment codes. Since COVID, and we're not quite sure why, we may return to that level, but for, I think the first year was 2021, 2020, 2021. 2021, where we noticed there were excess funds. I think it was about 7 million. And then the next fiscal year, about 8 million. All of that reverted to the general fund in those years because we were so unaccustomed to having excess funds. The next year, we worked with FNA to ask for carry forward authority, thinking if this becomes a trend, then we would want carry forward authority to make sure we can fund things like an attorney rate increase going forward. So far, we have 1 year example of carry forward money, and it's the 10.4 you just referenced. If that continues, and we don't know that it will, but if it does continue, then there may be the opportunity to address some of the pressures on the fund out of carry forward monies. But I think it's a bit premature and to start to increase rates that will be recurring out of a one-time carry forward.
Okay. All right. Well, thank you. And I certainly appreciate your hard work on this, as well as, it really spoke to me when Judge Walden, sent that letter. That said a lot. So certainly appreciated that as well. But thank you very much. Thank you, Madam Chair.
Representative Barrett.
Thank you, Chair Lady. I know we're up against a hard break here, so I'll try to make this quick. Good morning.
Good morning.
You referenced the $50 an hour for indigent pay. I'm an attorney, so I'm very familiar with this. And I just want to make this illustration so that everybody understands this. We had our AG come in earlier. He talked about the average starting salary in Nashville right now is about $160,000 for a new attorney fresh out of law school. At $160,000 an hour, if that attorney takes nothing but appointed cases at $50 an hour, gets paid, we're talking 3,200 hours in order to cover that 160. That's 62 hours a week that they would have to work in order to just pay for their own salary. Has there, and I know we're talking about a lot of money from the state in order to increase this, but has there been any discussion or thought about tying this to a percentage of an attorney's hourly rate? For instance, it's different when a second-year lawyer gets appointed versus a 20-year lawyer gets appointed. First of all, 20-year lawyers don't get appointed. Let's just be honest. They're not getting appointed to cases. They have the relationships and the ability to not have to deal with that. But in a perfect world, let's say everybody's on the same playing field. We're all getting appointed at an equal rate. It's a different impact for somebody that's billing at $600 an hour, their private clients, versus somebody that's starting out billing at $150 or $200 an hour. So if we were to tie this of what they're going to be reimbursed to some percentage of what their current hourly rate is, would that not be a more equitable way of doing this and perhaps get more participation from lawyers across the state?
So I will say that the court is open to discussions about ways to think about this work differently, and that certainly is one way of doing it. The person who's done the research, though, on my team as to what other states have done and how they've wrestled with this issue, and all of them do, is Joe Byrd. And so I'm going to turn to him to see how he would answer your question.
The suggestion that you have certainly is not one of the other states that do it. I'm not saying that it's not workable. I just haven't seen the example. The closest would be actually something like Alaska that changes the rate based upon experience. So that would be the closest model I could see. My biggest concern would be, how do we forecast out what the budget would be needed based on that? Because really what we are able to capture in the data doesn't necessarily tell me the years of experience that a lawyer would have. So it'd be hard to forecast. I would, though, heartily agree with you that the attorneys who have the longer time in practicing are not being appointed. And that is part of the crises that we're seeing, that we're not just not having attorneys, as Judge Walden has already been mentioned here, but we're also not seeing the level of experience in some of these important cases that are not just capital cases, but AB felonies. So something like that could be explored. It would take some time for us to try to figure out how to properly set that up and to even give a forecast. But it would be reinventing the wheel. For me, I don't think that there's any model out there that I'm aware of.
Representative Barrett, final question.
Final question. I'll beat my a dead horse again. What we approved some additional judges in the current fiscal year budget. You've come back and asked for 4 more. There's one already approved, or one already at least included in the governor's recommended budget. As you look at, and you've referenced your population change, it really needs to be, comparatively speaking, there needs to be a reference to the current number of judges that you have. So as I'm looking at the information that you provided, 4th, 19th, and 23rd, 5, 7, and 3 judges covering a different number of counties, which also includes a different number of courts. If you've got 5 counties, you're covering at least 10 state courts, probably more, depending upon what all is included in that. And by my own data, just looking at that I've done and researched, currently the 23rd Judicial District, and I'm openly a homer for the 23rd. I'm going to admit that right here in front of everyone. But with 3 judges covering 5 counties that has a population of over 136,000 people, each judge is essentially assigned to cover 45,000 people. That's insane, and it's untenable. And I know that the 23rd is not the only district that's dealing with this. It's just the one that I'm familiar with. And so, again, it's not so much a question as a statement as these judges are not a luxury. They are a necessity. We have to get the courts funded.
Representative Barrett, there'll be another time for advocacy.
Yes, ma'am. Thank you for your time.
Chairman Williams.
Thank you. Just as a follow-up to that, though, when we do the caseload studies to determine where we need additional judges across the state, we do that based upon caseload. Is that correct? We do a caseload study. And so, for instance, there might be a community that the number of crimes is higher, but the population is lower. So it's really based upon case study and the caseload, and not necessarily demographics or population based.
That's absolutely true. It's based on cases or caseload and a time study that applies an appropriate amount of time per case. That's the formula that the comptroller uses.
All right. I don't have any additional questions on the list. You've given us a lot to think about, particularly on the indigent fund. I think we'll look forward, maybe this time next year, we'll have a better handle on what your reserve fund will look like, to looking at ideas and ways to move that number up. It may be that we're being penny wise and pound foolish if we are not getting experienced defenders. Then we may be looking at longer process if we have folks who are claiming ineffective counsel down the road, or those sorts of things. So there's a lot to look at and to think about it in terms of how the whole process works. And again, whether that's tying it to a position or a salary is problematic in my mind, because that differs statewide. Attorneys in Chattanooga or a rural area don't get the same hourly rate as in metropolitan areas and that sort of stuff. But I think it's something that we definitely need to look at. And Mr. Byrd, I understand you're looking at other states, and particularly would be maybe in a position to offer us some ideas for models that from other states that seem to be working better than what we're doing here. So we look forward to having additional discussions about that. We are way past time, and some of us got to go straight into a meeting. Chairman Hicks will let you talk about that in just a moment, but without objection, we are back in session. That does complete our work for today. I will remind you that budget hearings will begin again Monday morning at 9 o'clock. Contain your excitement, and we will plan to see you here again on Monday. Chairman Hicks, do you have an announcement?
Just a reminder, Budget Sub will be meeting in House Hearing Room 3 at 10:30.
All right, thank you. Is there any other business? Seeing none, hearing none, we are adjourned.